University of Kansas v. Sidney Look, ticket number 319832 on September 22nd, 2015 at 2:09 a.m. for restricting the flow of traffic in Lot 104 of Ellsworth Hall. Appellant appears by Nolan Wright, defense attorney, Katie Court Parking Fields.
Thank you, Mr. Wright. Prosecution, please enter your appearance.
The University appears by Allison Desert, University attorney, Katie Court Parking.
At this time, are there any motions, pretrial motions that need to be addressed?
No, Your Honor.
All right, are any witnesses present, Mr. Wright?
No, Your Honor.
All right. Then at this time, since no witnesses are present, we will proceed directly to our closing arguments. Defense, you will have 7 minutes. Would you like to reserve any of that time for rebuttal?
2 minutes, please.
2 minutes, all right. And Mr. Wright, if you would just do us a favor and speak up as loudly as you can, since we do have some fans running in
I
here.
really don't have any problems with the volume.
That's great. You may proceed whenever you're ready.
May it please the court. Ms. Look's citation should be dismissed for 2 reasons. One, Ms. Look's citation was given without enough evidence to support the university's case. The ticket was for restricting the flow of traffic, not for parking in an unmarked stall. Public safety officer or parking transit provided no photos of the location to show how this would be restricting the flow of traffic. And Ms. Look states in her appeal that she was parked in a very back corner in a wide thoroughfare that would not have restricted the flow of traffic. The lot has significantly changed since the time of this citation, so evidence as to what the law looks like now that we would be able to gather would not be significant or to the outcome of this case. Finally, the second reason, if you would not take the first, would be that the equities weigh in the favor of Ms. Look. According to University versus Cray, this court is a court of equity where we would weigh the equities of the appellant versus the university to see whether or not the ticket should be upheld or dismissed. Ms. Look states in her appeal that she was afraid for her safety. She was returning from a Taylor Swift concert around 1:30 in the morning back to Daisy Hill.
All right, Mr. Wright, I'm actually going to interrupt you right here, and I would actually like to go back to your first argument that the university did not provide enough evidence to support this ticket. What would you say in response to the fact that this court presumes that an officer's discretion is correct in issuing citations?
I would say that this lot was supposed to be changed. We knew that we wouldn't be able to get any evidence prior, so when he writes out the ticket, they should be able to take a quick photo. And having done numerous parking citation cases, I've seen many dockets where a photo was taken when...
Counselor, what you've seen isn't really relevant to this case right here. Please don't testify. In the University v. Bibby, the court assumes that a ticket was properly given unless the appellant gives a complete denial to the contrary and gives evidence to support that. Did Ms. Look give a complete denial to the contrary?
Ms. Look in her appeal did state that there was no way that she could have been restricting the flow of traffic. This ticket was not for parking in an unmarked stall, which she did admit to. However, that is not what the ticket was for. Ms. Look did say that there's no way that she was restricting any of the flow of the traffic, and because the citation was at 2 a.m., I'm not sure there was much traffic to prevent the flow of. However, even if you would uphold the ticket based on this, the equity still lay in favor of Ms. Look. She had a specific fear for her safety, not just a general fear of it being at night returning at 1:30 in the morning. She saw several suspicious people who made her scared for her own safety. Now, in the defense, or in the university's packet, she cited the personal safety property theft, and they say to look around your vehicle when walking around it. If they see anybody in the area that makes you uncomfortable, do not approach it. It also says that if someone makes you feel uncomfortable, the situation does not seem right, trust your instincts and leave. Now, these...
Counselor, how reasonable does the appellant's fear need to be?
I believe that this is a personal safety issue. A person with a reasonable fear, if you're walking home alone at 1:30 in the morning, I believe a reasonable person would show that they are pretty scared. Single 18-year-old girl, I think that's to be considered reasonable. Now, in addition to all of this, in University v. Huntsman, they talk about the pursuit of alternatives and weighing of the equities. Ms. Looks states that she tried to call her friends to see if they would walk with her from her car back to the dorm. However, since it was 1:30 at night, she wasn't able to get hold of any of them. She also got up 4 hours later, as soon as the sun was up, to move her car so that she wouldn't be restricting any traffic or anything like that. So this shows that she did actually make attempts to mitigate the situation as quickly as possible when the sun risen and her fear for her safety had been taken care of. Now, I believe that it is on this manner that this citation should be dismissed.
Thank you.
Prosecution, are you ready to present closing arguments?
Hi, everyone.
All right, you shall have 7 minutes, and you shall begin whenever you are ready.
May I please report? This citation should be upheld because the appellant does not have an excusable reason for parking illegally and restricting the flow of traffic. This ticket was accurately issued, and her actions are not justified because 1, she had options to further ensure her safety that would not involve endangering the safety of others. 2, she had notice of these options, and 3, she had subjective knowledge that the Daisy Field lot filled up because she had to try to park there once before and had the parking in the center. My opposing counsel argues that Cape Parking Appeals has not given enough evidence to warrant the citation. That, however, this was not the appellant's argument that she should not have been issued an unmarked stall. She should have been issued an unmarked stall citation versus restricting the flow of traffic. And as defense counsel pointed out, where this appellant attempted to park may not exist in its exact form. Now the McComb has been torn down, but if you, I invite you to look at the parking map on page 8 of my evidence pack, and this is how the parking would have looked when Ms. Long parked there. And if you look just below on the floor where the motorcycle marking is there would have been a chain link fence under there blocking off McComb at the time of this ticket issued. So it's very likely that she parked simply just at where, in the final photo in my evidence packet, it's not necessarily where she parked where, but it is an example on page 20 of what the type of area in which she may have parked. And it's basically a drive-through area. And so while it's not a fire lane parking, it's certainly, if there were to have been a fire at McComb or one of the dorms that evening, it certainly would have restricted the flow of.
Counselor, but isn't the citation restricting the normal flow of traffic? So assuming an emergency, that would be an abnormal flow of traffic.
That's fair to say, Your Honor. I would argue that, the university would argue that if students chose to park in areas that they deemed out of their own subjective awareness were still okay to park in because there'd be enough room for other cars to pass through, the university would have a chaotic situation on their hands. Therefore, that citation is issued in order to just keep the basic levels of space needed in order for individuals to turn around, to navigate without having to be in such confined spaces.
Counselor, I want to go actually back to your argument about how the citation was accurately issued by the university. According to our university or our court precedent, Menzie and Aika, what evidence do we have from parking here about whether the ticket was actually appropriately given? It seems to me that a picture from the officer would have been very easy. So why shouldn't we give deference to the appellant here?
Well, the university would argue that, first of all, foreign court rules do not require for our officers to take photos every time that they get a citation.
Well, what is good policy for that?
I'm sorry,
What is the good policy behind that?
for not having to take photos.
Yeah, every time.
Citation. It's simply just a matter of efficiency with the board. You know, in a certain case, there was no evidence brought to my attention prior to this that there would be any kind of argument about what the citation, that the citation wasn't correctly ordered.
Okay.
And so,
Counselor, but isn't it relevant for our considerations whether or not this ticket was in fact a violation that the appellant committed? Because we can't hold the appellant to a violation that she did not in fact commit. So isn't it relevant in every case whether or not the citation was correctly given?
yes, Your Honor, and we would argue that she absolutely parked in a way that restricted the flow of traffic. She parked in a spot that is also a non-marked zone. Technically, our officers could have issued her 2 violations because there's the flow of traffic. That road is there intentionally for traffic to flow, and so she parked there, and she parked in an area that was a non-marked stall. If you park in a non-marked stall in a normal parking lot, you're going to get a citation for that, but you won't also get a citation for for restricting the flow of traffic. So technically, she could have been issued 2 citations. I'd like to return to the arguments that Ms. Look did have options that evening. The university puts measures in place to ensure our student safety. These include the blue light phone. If you turn your attention to my photo packet, my photos in my packet, the first photo is a picture of the lot where she could have parked in the Lee Center. You'll know how well it is lit. Those first 2 pictures. You'll also know these were taken at 11 o'clock at night. And then the next picture on page 17 is a picture of the blue light, which is an emergency phone that students may use at any point.
How many blue lights? Sorry, Counselor. How many blue lights are there from the walk to the lead lot to Daisy Hill? Only one? Okay.
And then the next picture on page 19 shows how well lit the Lee Center bridge. And I apologize to our witnesses that are to our witnesses in the courtroom who are not able to see these photos, but there is you can see how well lit the bridge is. It's over Iowa Street, so you have all of the traffic going across as well as the lights. So arguments that she's not going to say, hey, that's a subjective feeling.
But what about her argument that she had an actual personal fear? Typically, when this court upholds a citation for subjective safety concerns, there's not a personal fear present. So how do you respond to her personal fears here?
The personal fears must be measured against an objective, whether or not it's sufficiently objective to a reasonable person. My defense counsel cited Craig. However, in Craig, there was evidence submitted that the area in which Babylon Park was very dangerous. We've seen no evidence today of that this area, that there was any crime or any reasons for her to feel unsafe. The appellant cited that she saw some individuals that were, in her words, made me very nervous and scared. However, they were not in the Lee Center parking lot. They were most likely outside of her door.
Well, Mr. Wright brought up, your opposing counsel brought up a very interesting point that in your very evidence packet, the personal safety tips specifically say you should trust your gut. So how do you respond to that argument?
Again, trusting the gut is also involves planning and preparation. Trusting the gut instinct is, I'm going to drive from Kansas City to Kansas City as a freshman. I've known that sometimes this parking lot fills up.
You can have leave to finish your thought.
Thank you. I know this parking lot fills up. I need to plan ahead. And my gut says that maybe I won't have a parking place when I get back, so I should have a safety plan in place versus endangering the safety of others by parking illegally.
Thank you, Ms. Desert.
Thank you.
Defense, rebuttal?
You have 2 minutes.
May I please support? In her argument, the university brought up a couple of different points. One, she said that that the suspects that were making Ms. Look feel unsafe were most likely in one of the dorm lots. We don't know this from any of the evidence presented. For all we know, they could have been in the Lee Center lot. Now, all we know is that there were people around that were making her, specifically because of these people, feel unsafe from parking in the Lee Center and walking over to her dorm. Now, she felt safer by how she did park. I don't think it's up for us to create evidence of where these people would have been. Now, safety should be a concern higher than that of parking, how she was speaking that she was putting the safety of others in danger. I don't see how her parking in the manner that she did in the back corner of a wide thoroughfare would have presented any safety.
Mr. Wright, I kind of want to undercut your previous argument where you cite to Ms. Desert's packet in that under the personal safety tips, one tip says walk in well-lit areas and on established paths. Isn't didn't she present evidence that the path from the lead lot itself to the dorms was just that?
As I stated in my early argument, we don't know the exact conditions of the law as they were a year ago because there was significant amounts of construction in the years since. And
To what?
Your statement that the lead law is not, it's not been changed since
So misrepresent.
that is not.
Okay.
objection.
Yeah, sustained.
And furthermore, my client did not park for convenience. It was because of a specific fear. Now, the court has upheld citations when there's just a general fear of parking and walking at night. However, there's a specific fear of specific persons on there that were making her feel unsafe. And under the
You may have leave to finish your
under
thought.
the advice given out by the Public Safety Office that you should trust your instincts and avoid people that are scaring you or causing you any sort of fear.
Thank you. Now, typically at this time, we would ask the attorneys to leave so that we would deliberate, but we are going to skip that step in the interest of efficiency because we'd like to talk to you guys, get to know you all a little bit better, and tell you a little bit about what we do here at Traffic Court. So, Nolan, Allison, thank you. Round of applause.